Good day, Crime Talk aficionados. We have a great show for you today. First, Stephen Goncalves has something to say about the Bryan Kohberger case. Charlie Adelson's request for a new sentencing hearing is denied. A man goes to jail over the adjustment of a thermostat. Man says it was worth it. I will explain. Will it end in trial for the It Ends With Us lawsuit? This day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and remember, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, that's right, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you will be able to do a background search on anyone here in the United States, and you're going to get a background report emailed to you literally while you wait, and it's going to have everything you want to know about that particular individual. So go to crimetalksearch.com. You're going to be happy you did. All right, it is Tuesday, January 28th. So what does that mean? That's right, it's our Tuesday night live program. Please join us 6 p.m. Mountain Time. I think we'll also set up the phone lines so that you can call in as well, and we'll talk about what you would like to talk about. Any case you want to talk about, let's do it. 6 p.m. Mountain Time. All right, let's go ahead and open the record for the 28th of January, 2025. So, like I said, Stephen Goncalves has something to say about the Bryan Kohberger case. And as you all know, if you've been following Crime Talk for a while, the trial of the quadruple murder suspect, Bryan Kohberger, approaches. The father of victim Kayla Goncalves, Stephen, is sharing his perspectives. Now, he gave an interview and expressed the immense pressure his family has been under since these legal proceedings began, obviously as a result of the death of their daughter. Now, Stephen emphasized the importance of transparency in the trial process, stating that he feels like anything that the jury's going to see in the courtroom, that he should be allowed to see it. And you shouldn't run from the truth. You shouldn't hide from the truth, even if it makes somebody look a little guilty. So that's part of the work that still needs to be done. He doesn't believe that there's enough transparency in these proceedings. So he says we need to get to the point where we say if the evidence is all agreed upon, the facts are the facts, then it's not going to contaminate the jury. Now, jury selection is scheduled to begin on July 30th of this year, and with anticipated trial actually starting with the presentation of evidence on August 11th. Now, I don't disagree with Mr. Goncalves in this particular perspective. Obviously, his daughter was brutally murdered, and he wants to know the facts of what happened. And if Mr. Kohberger is the guilty party, let's get this thing rolling. I get it. But you have to remember, the prosecution and the defense basically agreed that they weren't going to talk about the facts because they thought it was going to taint the jury. I'm a firm believer in openness when it comes to court proceedings, and if it's in those court proceedings and it's public record, it should be available to the public. Now, certainly you have to redact a few things as it relates to, Social Security numbers or some type of information like that. But unfortunately, when you have a criminal trial, welcome to the unfortunate situation where this information is going to come out, and it may be embarrassing to some people and make people look bad as well. But that's the truth. Now, I understand the evidence should not necessarily be disclosed to the public until after the trial, but the pretrial pleadings should be made available. I don't like the way that Idaho has done this, whether it be the Lori Vallow trial, the Chad Daybell trial, or the Bryan Kohberger trial, where everybody acts like everything is so secretive. I just don't get it. And I understand the courts are trying to protect the rights of the defendant, and the defense is trying to protect their client's rights. But at some point, the people have a right to know what the heck is going on. How do we know if the prosecutors are doing any good? How do we know if the defense has legitimate issues? Well, it should be made public, and normally what we should be able to have complete unrestricted access to are those legal filings. So, Charlie Adelson, remember him? That's right, plotted and was found guilty of killing his brother-in-law. He wants a new sentencing hearing, but the judge back in 2023, a guy by the name of Judge Stephen Everett, sentenced the periodontist to life without the possibility for parole in regards to the death of his brother-in-law, Dan Markle. Now, Adelson was convicted of charges of conspiracy to commit first-degree murder and solicitation of first-degree murder, for which he received the maximum sentence of 30 years on each to be served consecutively. So recently, Mr. Adelson has been trying to seek a resentencing, not on the murder conviction, but on the charges of conspiracy and solicitation of murder. Now, when the judge issued his ruling, he said that there were some errors on Adelson's sentencing score sheet, but they had no reflection on his ultimate sentence. The judge did, however, grant Adelson's request for a new corrected score sheet, which could affect his confinement. They score various points and things like that. Anyway, in the order, the judge wrote, when the court imposed its sentence, it did not refer to or mention the score sheet at all, demonstrating the court was not relying on the computation of the lowest permissible prison sentence. Now, in some states, judges use sentencing score sheets to determine appropriate sentences for those convicted of crimes, and the score sheets allow judges to calculate a numerical score when they factor in the severity of the offenses and other factors such as whether an individual has prior convictions. Score sheets essentially help make the sentencing fair and consistent across the board in similar cases. I respectfully disagree. I think legislatures, when they pass laws, should simply say, this is the maximum sentence, and the judge, the person that we impose trust in to do the right thing, to look at the sentencing factors, can come up with the appropriate determination. I hate when they do these little score sheets. It's kind of like the federal sentencing guidelines, where you start off at a 30, then you're down 3 for acceptance of responsibility, but then you get enhancements, so you go up 2, then maybe you're a minor participant, and you're down 2. It's ridiculous. Whether it's a state judge or federal judge, we trust them to do the right thing, to look at the principles of sentencing, of deterrence, punishment, rehabilitation, deterrence for others, to make the victims whole, restitution. The judges take those into consideration on every case. They don't need a score sheet to go through it like we're a bunch of 2-year-olds. Anyway, the defense attorneys for Mr. Adelson disputed the 120 of the 258 points that Mr. Adelson got on his score sheet, and basically thinks that it would make a big difference if they were to change the score sheet. The judge says, hey, I'll change the score sheet if you like, but the sentence remains the same. Now, in the Adelson case, the crime of murder is a capital offense, but the state opted not to pursue the death penalty. And therefore, Adelson's attorneys argued that when the court checked the life on Adelson's score sheet, they should have included the actual sentence of 60 years, 30 years for each conspiracy and the solicitation. Earlier this month, the court denied Adelson's most recent attempt to an appeal, and he was seeking a new trial on the grounds that a conflict of interest arose when his mother, Donna Adelson, hired the same attorney as him. As you may recall, the attorney had to conflict off the case. Now, Donna Adelson, who hired a whole new defense team, is currently awaiting trial for the same offense as her son. Now, Markle's 2014 death was a murder for hire orchestrated by Charlie, according to the prosecutors. With the help of a go-between, Adelson arranged for a hitman to gun down Markle, who was a Florida State University law professor. And at the time of his death, Markle was in a bitter custody battle with the ex-wife, Wendy Adelson. Wendy is Charlie's sister and Donna's daughter. The Adelson. I can't wait for Donna to go to trial. That ought to be good. I can't wait for the defense to try to explain away how she was literally this close to slipping away off to Thailand when she was arrested. Next, a man's probably going to prison for a long time over a dispute over a thermostat. That's right, ladies and gentlemen. Let it go. Anyway, a landlord in Miami allegedly murdered his tenant after a dispute about the temperature setting on a thermostat when the temperatures in South Florida, got down into the 40s. Can you imagine such a thing? Anyway, Adam Luis Anson lives in his home down there in Florida, and he has a gentleman who rents a room as a tenant. Anyway, the home's thermostat is located in a hallway within this living arrangement. Anyway, Anson allegedly armed himself with a handgun and went to the apartment side of the home around 8 a.m., knocked on the window with the intention of changing the setting on the thermostat, and the victim, Carlos Alberto Gonzalez, opened the door. That's when Anson forced himself into the efficiency room and began to punch the victim unprovoked, according to the police. Anson allegedly then dragged Gonzalez outside to the backyard, where he shot the victim several times in the head. Anson then walked inside the apartment and adjusted the thermostat to his liking before returning to his side of the home and calling 911. Needless to say, emergency personnel arrived at the scene. They were unable to save Mr. Gonzalez. Now, Anson claimed self-defense. He said that Gonzalez tried to punch him, so he pulled out a gun and shot him. I guess the jury's going to have to decide whether that was truly self-defense. I don't know what to say, ladies and gentlemen. I mean, somebody died over a thermostat. It just blows my mind. But keeping with that theme of the day, let's talk about this guy. This guy in Texas is going to spend the remainder of his remaining life on this earth behind bars for killing his father after shooting him 6 times in the back of the head while his dad was eating a salad. And then he told the 911 operator, wow, that felt great. Yes, it's true, ladies and gentlemen. You can't make this stuff up. So Jacob Hickman is going to serve life in prison for the killing of his father, Paul Stotzenberger. Now, back in June of 2022, the police responded to a shooting at the Hickman's home in Canyon Lake, Texas. Apparently, that's about 60 miles southwest of Austin. Anyway, when the police arrive, Hickman himself placed the 911 call and immediately confessed that he just killed his father, telling the emergency dispatcher he had emptied 6 rounds into the victim. Now, Mr. Hickman remained on the line, having a conversation with the dispatcher for about 20 minutes or so, and he acknowledged that he needed to control his anger and that he was fully aware of the consequences of his actions. But he said, you know what? I can't say I'm sorry. This is to the call to the dispatcher. To be honest with you, I feel so effing great. That's what he told the dispatcher. I mean, horrible thing to do, but in a small, deep, dark place where places we don't like to go to, you kind of like people that at least accept responsibility and they know that their punishment is coming. It's kind of refreshing in its own little way. At least he didn't say it was self-defense, right? Anyway, when the police got to the scene, the first responder was there. Needless to say, Dad was dead. He'd had 6 gunshot wounds to the neck and head. That ought to do it. Upon further investigation, the police determined that the victim, the father, was shot while he was seated on the couch eating a salad. And apparently it felt so effing great, according to his son. But you gotta love that sort of sense of honesty. You know what I mean? He knows he's going to prison, knew he's got to control his anger, and you just do 6 shots to the back of the head of your dad while he eats a salad. Cold-blooded. But I appreciate the honesty. I appreciate the candor. I really do. Had a case once where, let's just say, a knife was involved and several people were dead, and client picks up the phone, calls 911, and tells them what happened. And they're like, well, where's the knife? Well, I'm holding it right now. You got to appreciate that. Anywhere, does it end here for the It Ends With Us lawsuit? That's right. Does it end in trial? A federal judge set a trial date in March of 2026 and moved an initial conference from mid-February to next week as the public feud between Blake Lively and her It Ends With Us co-star and director Justin Baldoni continued to grow and pick up speed. Anyway, this new and separate front in the series of the legal battle surrounding the film that became a surprise hit last summer. I've seen it. I actually thought it was really good. Now, the judge also moved an initial conference from mid-February to next week and told the lawyers to be prepared to address complaints about the pretrial publicity and the conduct of some of the attorneys involved. The judge took the action after Lively's lawyers claimed in a filing on Monday that an attorney for Baldoni was trying to taint potential jurors over lawsuits the actors have filed against each other. Now, the lawyers allege that Baldoni's attorney was trying to wreck Lively's career and turn potential New York jurors against her by creating a website to release selected documents and communications between Lively and Baldoni. The lawyer said attorney Brian Friedman, representing Mr. Baldoni, was engaging in extrajudicial campaigns to influence these proceedings and the public perception of legal filings to this court, and that there is already a serious risk that this misconduct is tainting the jury pool. The motion added, the endless stream of defamatory and extrajudicial media statements must end, Friedman said in the statement, in response to Monday's assertion that the irony is not lost on anyone that Miss Lively is so petrified of the truth that she has moved to gag it. We will always respect the court. However, we will never be bullied by those suggesting we cannot defend our clients with pure, unedited facts, the lawyer noted. He continued and said, all we want is for people to see the actual text message that directly contradict her allegations, video footage that clearly shows there was no sexual harassment, and all the other powerful evidence that directly contradicts these false allegations. Now, in a letter to the judge Thursday, Baldoni's attorney, a guy named Kevin Fritz, accused Lively of a publicity campaign that left Baldoni and other defendants the objects of public scorn and contempt. Can you imagine such a thing, ladies and gentlemen, when you file litigation to say bad things about people? Anyway, he said actions had damaged those that she sued so that they were exiled from polite society and suffered damages totaling hundreds of millions of dollars due to Miss Lively's scorched earth media campaign. In a separate filing in Hayes County, Texas, a precursor to another potential lawsuit, Miss Lively asked for an order for a deposition from Jed Wallace, a crisis management specialist she alleges was behind much of the social media manipulation surrounding the film that turned public sentiments against her through posts on Reddit and TikTok. Now, Wallace and his Texas-based firm, Street Relations, were brought on as subcontractors by publicists working with Baldoni and his production company. He weaponized a digital army around the country, including New York and Los Angeles, to create, seed, manipulate, and advance disparaging content that appeared to be authentic on social media platforms and internet chat forums, the filings allege. Now, Wallace is identified in Lively's federal lawsuit, but he is not named as a defendant as of yet. Anyway, Miss Lively sued Baldoni, his production company, and others in New York in late December for sexual harassment and attacks on her reputation and asked for an unspecified money damages to be awarded. Baldoni sued earlier this month, accusing Lively and her husband, Ryan Reynolds, of defamation and extortion, seeking roughly $400 million in damages. Probably what Ryan Reynolds is worth, or maybe he's close to a billionaire. I don't know. He's a funny guy, though. Anyway, the judge said Monday that he'll likely combine the lawsuits for trial. Anyway, It Ends With Us is an adaptation of Colleen Hoover's best-selling 26 novel that begins as a romance but takes a dark turn into domestic violence and was released back in August of last year, exceeding box office expectations with a $50 million debut. But the movie's release was apparently shrouded by speculation over discord between Lively and Baldoni. Lively came to fame through her 2005 film, The Sisterhood of the Traveling Pants, and bolstered her stardom on the TV series Gossip Girl from 2007 to 2012. And she has since starred in films including The Town and The Shallows. Baldoni starred in the TV comedy Jane the Virgin, 5 Feet Apart, and wrote Man Enough, a book pushing back against traditional notions of masculinity. It's going to get ugly, ladies and gentlemen. You thought the Johnny Depp trial was going to be a circus. Wait for this one. It's going to be good. I like the movie. I know the guy, Baldoni, was the actor and the director and whatever. Lively was good in it. But Ryan Reynolds is funny. I mean, if I got to pick sides, I got to go with Ryan Reynolds. I just think the guy's funny in Deadpool. But that's just kind of the humor that I like. I don't know what to tell you. I don't know much more about it other than that. But I like Ryan Reynolds. And he's married to Miss Lively. If you got to pick a team, I guess that's how we got to do it, right? Let me know what you think. Anyway, this day in legal history, January 28th, 1909. What happened? The United States ended direct control over Cuba which had been established following the Spanish-American War. Needless to say, it set the precedence for U.S. foreign policy and territorial governance. And then, of course, the communists got it. And what do we know about communists? They ruin everything they touch. Such a beautiful place. The beaches look amazing. The best thing in Cuba right now was probably, cigars and Gitmo and amazing beaches. I almost got to go, 8 years ago or something, but then everything got messed up. And anyway, I would love for it to go back. I would love for the communists to go away so that we can go to Cuba. It's like 90 miles. I've flown down to the Keys, and then on a clear day, it's my understanding you can see Cuba from the edge of the Florida Keys. Anyway, next, on this date in 1932, Wisconsin enacted the first state unemployment insurance law, which led to the federal unemployment insurance law a few years later. And on this day in 1986, I can remember it like it was yesterday, the Space Shuttle Challenger exploded 73 seconds after liftoff from Cape Canaveral, killing all 7 crew members. And then on this date in 1925, the United States Attorney General Harlan Fiske Stone became the first U.S. Supreme Court nominee to have to appear before the Senate Judiciary Committee, testifying for some roughly 5 hours. Well, how did that happen, right? Apparently, they nominate him, they send him on up. Well, on January 5th of 1925, President Calvin Coolidge nominated Attorney General Harlan Fiske Stone to a vacancy in the United States Supreme Court. Commentators around the nation readily agreed that Stone's character, learning, and temperament perfectly fitted him for the job. Within days, however, it turned political, and complications arose that threatened Stone's chance for an easy Senate confirmation. The source of the trouble was Senator Burton K. Wheeler, a progressive Democrat and former U.S. attorney from Montana. So the previous year, Wheeler had launched an investigation to determine why Stone's predecessor, Attorney General Harry Daughtry, had failed to prosecute government officials implicated in the Great Teapot Dome oil leasing scandal. As a result of Wheeler's probe, Daughtry resigned in March of 1924. A month later, Stone, settling in at the Attorney General's office, a federal grand jury in Montana indicted Senator Wheeler on charges related to the conduct of his private law practice. Seeing the indictment as an effort to discredit his continuing investigation of the Justice Department, Wheeler asked for the Senate to examine the charges against him. And following a 2-month inquiry, and without waiting for the Montana court to dispose of the case, the Senate overwhelmingly exonerated Mr. Wheeler. Now, the Wheeler case tormented Attorney General Stone for months. Friends of Wheeler urged Stone to drop both the Montana case and the new information that led to Wheeler's opposition to seek a second indictment. Stone explained that he felt bound to pursue the second indictment, even though it involves a sitting senator whom the Senate had recently investigated and cleared. The Senate, he said, is just not the place to determine the guilt or innocence of a man charged with a crime. And then on January 24th, 1925, 5 days after the Senate Judiciary Committee had recommended Stone's confirmation, Senator Thomas Walsh, Wheeler's Montana colleague and legal counsel, convinced the Senate to return the nomination to committee for further review. President Coolidge refused to withdraw the nomination. He agreed to the unprecedented compromise. He would allow Stone become the first Supreme Court nominee in history to appear before the Senate Judiciary Committee. On January 28th, Stone's masterful performance during the 5 hours of public session cleared the way for his quick nomination. And now we do that all the time. Anyway, Senator Wheeler's soon won acquittal of all charges. And it wasn't until 1955, however, did the Senate Judiciary Committee routinely adopt a practice based on the precedent established by Stone's nomination of requiring all the nominees to appear in person. Yep, they used to just do it because the president got what he wanted because he figured these people were qualified. And everybody knew it at the time. But that's when it all turned political. And finally, our dumb criminal of the day. Now, ladies and gentlemen, I get it. People like clicks. People want to get views on their social media. But this is not a way to do it. Take a look at this video. Police in Texas say they are going to arrest a 25 currently unidentified man, but they know who he is, who put a 3-month-old in danger when he used the baby to wipe off snow from a car so he could put it up on TikTok. The man is accused of using the baby to brush the snow off a car earlier this week during the storm that hit southwest Texas. Police now believe this constitutes child endangerment. Like I said, the video shows the man using a baby to remove snow from his Hyundai Elantra. Apparently, they've confirmed that the baby was 3 months old. They know where he lives. There were 2 women also in the video. One is presumed to be the mother. They, too, could be in trouble. So our unidentified man, you are our dumb criminal of the day. And I've been thinking about this, ladies and gentlemen. I think I'm going to set up maybe an app or, an app. And people can call me or send me with questions, for a small fee. Should I do this? And they can ask me, hey, is it a good idea to post a video where I'm using a child to clean off the car? I get it, maybe cute, maybe funny. Was a baby in danger? Probably not. But really, don't do it, right? Remember what people used to say? Don't write that letter. Don't write that email unless you want that to appear on the front page of your newspaper in town. Same thing with videos, ladies and gentlemen. Are you sure if that video were to go totally viral, is it going to get you arrested? Think about it. Call the office for a small fee. You can ask, is this a good idea? And I will tell you whether I think it's a good idea or not. And at least if you get in trouble, I guess you could say, I relied upon advice of counsel. There you go. All right, that's all we have for you today, ladies and gentlemen. Thanks for joining us. Remember, 6 p.m. Mountain Time, we're going live. We'll have the CrimeTalk bat line number up so that you can call in and ask any questions that you would like to ask. So please join us, 6 p.m. Mountain Time. And remember, the Constitution matters.